Alrighty, everybody. For the sake of time and everyone getting out of here on time, we'll start. So welcome to the last session of the second day of the conference. The theme is a wide-ranging theme. So it's sexual violence, technology and prisons. So our first two speakers will be Ashley Pearson from the University of Sunshine Coast and Laura Hidderley from the Queensland Sentencing Advisory Council, and they will be presenting on the community views on the seriousness of sexual assault offending and comparison to sentencing outcomes.
Thank you very much. Hello, everyone. My name is Ashley Pearson. I am a law academic from the University of the Sunshine Coast, and I am here on behalf of our project team today. I'm also joined by Laura Hidderley from the Queensland Sentencing Advisory Council, who will be presenting on aspects of the analysis and the impact of this research. So today we will provide an overview of a collaborative research project that was undertaken last year on community views regarding rape and sexual assault sentencing. This project aimed to examine how the community perceives the seriousness of sexual assault and rape offences when compared with other offences, and ultimately whether the community's views align with the sentencing outcomes for these offences. Before we begin, I do want to note that some of these slides do contain explicit textual descriptions of rape and sexual assault. So if anyone feels uncomfortable, please feel free to leave the room or look away as needed. So we know that sexual assault, violence cases have long-lasting detrimental impacts on victim survivors, including physical, psychological, and social impacts. These impacts also extend to the broader community, especially when the community feels that the legal system is not responding appropriately in sentencing these offenders. There is a clear need for alignment between the criminal justice system and community views to ensure sentencing reflects public sentiment as well as fosters confidence in the justice system. So as a result, we conducted a series of focus groups with Queensland community to ask their views on rape and sexual assault offences. To determine whether community views align on these offences with the sentencing outcomes, we first needed to understand how the community perceives the seriousness of these offences, so of rape and sexual assault. As a result, we had two primary research questions. So the first one was, how does the community view the importance of sentencing purposes, such as just punishment, denunciation, and community protection for sexual assault and rape offences? Our second research question was, how does the community rank the seriousness of sexual assault and rape offences compared to other offences that are committed in Queensland? The Penalties and Sentences Act of 1992 Queensland establishes 5 different purposes for which sentences may be imposed. We were interested in which sentencing purposes the community prioritised or found most relevant to particular offences. Our analysis focused particularly on just punishment, denunciation, and community protection, as per our terms of reference. However, all 5 sentencing purposes were provided and explained to participants to minimise any bias that may occur towards our targeted sentencing purposes. This project used a mixed methods design, incorporating qualitative research and some quantitative elements. We chose focus groups because they allow participants to share, to challenge one another's views, and they tend to generate quite rich data. These focus groups have also been used in similar previous studies on child homicide and drug use as well, when gathering information on community views and sentencing outcomes. So we thought it was a fitting method in our case. Overall, UniSC conducted 19 focus groups with a total of 89 participants. Participants were required to be over 18, to speak English, to be a Queensland resident, and could not have been accused or convicted of a sexual offence in the past in order to be eligible for the focus group. As As it is a smaller sample size, this research was not intended to be representative of all of Queensland, but we aimed to provide a broad but hopefully nuanced understanding of the community's views on sentencing. Qualitative data from discussion was recorded, de-identified, coded, and analysed using thematic analysis, and we pulled out some emerging themes from the discussion. The quantitative data was used to create a general ranking system of offence seriousness. Focus groups were separated and convened in a couple of different ways. Firstly, we separated by gender in order to reduce any social desirability bias. Given the sensitive nature and topic of the discussion, we wanted to encourage and facilitate open, honest discussion on rape and sexual assault sentencing. So we thought that dividing by gender might assist with that. Secondly, we also split focus groups up by whether participants identified as a victim survivor or as immediate family members to victim survivors in order to ensure psychosocial as well as their own physical safety. As you can see by our demographics, we did have significantly more female participants than male participants. This reflects other research that has found that men are 60% less likely to participate in sexual violence programs than women. We also had a higher participation by individuals that identified with a victim survivor status, and we also faced some challenges in recruiting First Nations participants. Obviously, building relationships of trust with these communities does take time. Given the short time frame, we weren't quite able to get a good sample of that demographic. We were able to conduct one targeted focus group in Goondiwindi, but noting that this research is broadly not representative of First Nations voices or opinions. So in terms of what activities we actually undertook, we designed the focus group activities based on some excellent research by the Sentencing Advisory Council of Victoria regarding community attitudes and offence seriousness. So broadly, it was the focus groups ran for 2 hours and they were broken up into 2 parts, each focusing on a different research question. Part A, participants completed a short ranking exercise with no contextual information about the offences. And then they also worked through 3 vignettes, which were based on real Queensland cases and judgments. These contained detailed factual scenarios, including aggravating and mitigating circumstances, and participants were asked to identify from the 5 sentencing purposes provided the single most important sentencing purpose for each vignette. They were also provided with opportunities to discuss and explain their reasoning. In the second part, which focused on our second research question around seriousness, participants were asked to rank 26 paired comparisons. So essentially you had 14 short fictional scenarios that were paired up to produce these 26 pairs. And this included sexual offences ranked against other sexual offences, as well as non-sexual offences. The participants chose which offence in each pair was most serious or more serious. Although 26 pairs is not sufficient data for a comprehensive data set, each scenario appeared minimum of 2 times up to 5 times, and this did allow us to produce a general offence seriousness ranking. Following the conducting of this research, UniSC, the project team, conducted a thematic analysis of all of the participant discussions that emerged, and we produced 6 key findings. Firstly, we determined that offence type influences community views on sentencing purposes when there is no broader context provided. Without context, participants viewed sexual assault and rape as attracting different sentencing purposes based solely on the offence type alone. The second finding, the community differentiates the importance of sentencing purposes based on contextual factors. For example, community protection was prioritised when the perpetrator was perceived as dangerous, such as acting in public or acting in a premeditated way, whereas punishment was favoured when the victim was particularly vulnerable, such as a child. Thirdly, Victim survivor perspectives on the importance of sentencing purposes broadly aligned with the general participant responses, although victim survivors had some emphasis on community protection over punishment, whereas that tended to be flipped in the general. Our fourth finding was that harm and culpability factors were key factors in determining the seriousness of sexual assault and rape offences. The community emphasised psychological harm, acknowledging that there were long-term effects on victim survivors, as well as the difficulty in measuring this harm, especially when the extent of the psychological harm isn't known at the time of sentencing. Fifth, the community is victim survivor oriented when ranking offence seriousness. Participants would frequently put themselves in the shoes of the victim survivor and try and imagine how they would feel in their place, what kind of impacts would come from being the victim survivor of such an offence. Sixth, and finally, contextual factors such as whether the offence was public or private, the relationship between the victim and the offender, the victim survivor's age, the number of offenders involved in an offence, the longevity of the harm, and so on. All of these impacted on the community's perceptions of harm and consequently their offence seriousness. So, for example, sexual offences against children were rated as more serious than similar offences against adults. No sexual offence was ranked by the community as more serious than murder, the intentional killing of another, although high-level sexual offences, such as those involving children or multi-party rapes, were held to be of a similar level of seriousness to offences that were potentially lethal. So things like choking, things like grievous bodily harm. So these were our general findings. UniSC reported these findings and as well as the offence seriousness ranking onto QSAC, who then used them to further analyse whether the community views aligned with the current sentencing practices. So I'll now hand over to Laura to explain that process.
Thank you very much, Ashley. Yes, as Ashley mentioned, her team gave us some amazing data on how the community viewed the seriousness of certain offences that were committed. So at the Sentencing Advisory Council, we wanted to look at those results and compare it to the sentencing outcomes for those offence scenarios. The Queensland court data was analysed for cases sentenced between July 2020 and June 2023 in the magistrates' courts and the higher courts, and considered offences sentenced as the most serious offence sentenced within the case and where the person was sentenced as an adult. The intent was to match the offence scenarios as closely as possible to the data by matching the offence type, any circumstances of aggravation, the type of conduct, victim age, whether they were an adult or a child, and the type of relationship whereby whether it was domestic and family violence related or not. As this research formed part of the Council's terms of reference on sexual violence, the sentencing remarks for rape were extensively examined by the Council Secretariat. So this meant that the victim and conduct information was available to be directly matched to the scenarios for those rape offences. However, other scenarios could not be matched quite as closely due to the lack of data availability, as victim information and some conduct information is not recorded in the court's data. The closeness of matching the data to the scenarios varied quite widely. Here are some examples of the scenario matching to demonstrate the differing levels of matching the data to the scenarios. So for scenario 1, which involved the penile rape of an adult stranger, the court data analysed was limited to rape offences which involved penile rape of an adult who was not known to the victim. For scenario 6, which involved an aggravated form of sexual assault, the data was limited to sexual assault offences with the same circumstances of aggravation. In scenario 11, which was the murder murder in a domestic violence context, the data was limited to murder offences which had a domestic and family violence indicator. Scenario 12 involved dangerous operation of a vehicle with speeding and alcohol as circumstances of aggravation. So these circumstances were matched in the data. In Queensland, dangerous operation of a vehicle can result in grievous bodily harm or death, and these circumstances are not split in the data, so we had to include both forms. Also, the victim in the scenario was not known to the perpetrator, so offences with a DV indicator were removed from this case. And in scenario 14 involved strangulation of a woman by her husband. In Queensland, this offence is specifically a domestic violence offence, and as such, no filters were applied to this offence, meaning that all sentenced strangulation offences were included in this analysis. So for each pair of scenarios that community members looked at, they ranked which offence they thought was the most serious, and we looked at which one was ranked as the most serious by the most people. We then looked to see whether that offence received a longer median custodial penalty than the comparison offence. In most cases, the offence that most participants ranked as most serious also had the longest median custodial penalty. This suggests that sentencing practices for these offences align with community views about the relative seriousness of these offences. However, there were some exceptions. For 9 of the 26 pairs of offences community members ranked as most serious, the median custodial sentence length was shorter than the comparison offence. I'll now present some of these pairs that have discrepancies. So community members overwhelmingly felt that the digital rape of a child was the more serious offence in this pair. However, the median custodial sentence was 3.3 years. This is less than half of the median sentence for the comparison rape offence, which was 7 years. So in this pair, community members even more clearly felt that the digital rape of a child was the more serious offence. However, the median custodial sentence was still less, 3.3 years compared to 6 years for the comparison rape offence. I'll note here that in some of the pairs, some community members chose not to provide an answer to the seriousness ranking, so the percentages do not always sum to 100%, and there are some instances where it's a bit more clear they had difficulty choosing which offence was more serious. So the majority of community members ranked non-aggravated sexual assault of an employee by their employer as more serious than burglary at night when no harm was caused to the occupants. Despite Queensland courts imposing a longer median custodial sentence for burglary, 1.3 years compared to 0.8 years. So this next scenario pair had a less decisive outcome regarding which offence was seen as the most serious. Aggravated sexual assault was seen as more serious by half of the community members, while strangulation was seen as more serious by just under half. However, strangulation had a slightly longer median custodial sentence at 2.5 years compared to 1.8 years for aggravated sexual assault. However, enhancing this difference is the fact that there are widely different maximum penalties for these two offences. So the maximum penalty for aggravated sexual assault is 14 years in Queensland, and the maximum penalty for strangulation is 7 years. Just as a side plug, our colleagues at the Queensland Law Reform Commission are currently undertaking a review of the non-fatal strangulation. So if you're interested in that, look out for their final report in a couple of months. So 2/3 of community members thought that the dangerous driving offence was more serious than anal rape of an adult. However, the rape offence received the longer custodial penalty with a median of 6 years. The maximum penalty for aggravated dangerous driving is 14 years, which is much, but remembering that this penalty, this offence could also include the death of a person, not just grievous bodily harm, as in this scenario. So just under 2/3 of community members thought the intention to cause grievous bodily harm offence was more serious than penile rape of an adult stranger. However, the rape offence did receive the slightly longer custodial penalty, with a median of 7 years compared to 6.3. So further considering the 5 pairs of scenarios which only included rape offences, it shows that community views the child rape scenario the most serious form of rape, as it was ranked the most serious in each pair it was presented in. Where the victim was an adult, the in-company offence was ranked as the most serious, then penile rape of a stranger, which was in turn more serious than anal rape. Digital rape was seen as the least serious adult rape offence. So you can see here that even though child rape is seen as the most serious in offence ranking, it has the second lowest median custodial sentence. I will caution here that the in-company rape offence data has a very small sample of only 8 cases, so take that with a grain of salt. So our overall findings. Community members overwhelmingly thought that sexual offending against children was more serious than similar sexual offences against adults. The only offence seen as more serious in the child sexual offences scenario was the murder one. We found there was disparity between sentencing practices and the community views of offence seriousness. Specifically, the sentences imposed for digital rape of a child did not match the community members' views about the offence level seriousness. Despite the offence being ranked by the majority of participants as more serious than any of the adult rape scenarios, it had the second lowest median custodial penalty length. This shows that sentencing practices for the rape of a child did not adequately reflect community views of offence seriousness and suggests that current sentencing is inadequate. So as part of the full review, our council provided 28 recommendations to the Attorney-General and Minister for Justice. The council concluded that penalties imposed for rape are not adequate due to the failure to reflect the seriousness of this form of offending, with specific focus on offences against children. Despite substantive changes in legislation regarding child sexual offences, an understanding of the harm caused to the children of these offences, sentencing practices have not sufficiently shifted. So as such, one of the recommendations provided by the council was to progress amendments to Section 9 of the Queensland Penalties and Sentencing Act to require a court to treat the fact an offence of rape or sexual assault was committed in relation to a child as aggravating. All 28 recommendations were provided to the Attorney-General in February this year and are now with the government for consideration, and a bill is currently before Parliament. There is our website. You will find our full report there, as well as Ashley's team's amazing report as well. Thank you.
Okay, thank you for that. So we've got a little bit of time for some questions. Either put your hand up or put a question into Slido. Got one here. The microphone will get brought to you. 2 over here.
Hi, thanks for a great presentation. I guess I've got a couple of questions. Is it typical that the Queensland Sentencing Advisory Council, you know what I mean, relies on the public opinion to determine what adequate sentencing is? And is that, I guess you might provide a government answer, is that appropriate in your opinion to base that on the general public opinion as opposed to, let's say, judges who are, very experienced in providing their own sentencing decisions?
It was actually, that was actually a specific part of the terms of reference that we received from the Attorney-General to assess whether community views thought it was adequate. So it was something that we were specifically asked to do and then had to grapple with how we were going to do that. So it's not something we typically always do, but because we were specifically asked to do it, we had to.
Thank you for your presentation. I'm Minnie from the Australian Bureau of Statistics. Sorry if you already mentioned this at the start because I was a few minutes late, but the community members, just wondering for the community members, did they receive information about the history of the case or history of the defendant and offender? Victim and offender.
So I think in Part A, I think you're referring to, we had 3 different vignettes that were based on previous Queensland real judgments. We didn't actually tell them that they were real, so we said that they were fictional, so that they could kind of have honest discussion around the kinds of penalties or the kinds of sentencing purposes that they thought were appropriate there. We did include any like aggravating or mitigating circumstances such as criminal history, age and relationship of offender, where the offence took place, those sorts of things, but they weren't aware that it was real. At the time, and there were also considerable discussions in the room where saying, you know, if this were real, you know, we as community would be shocked and appalled if this were the actual outcome. So that was an interesting dichotomy for us.
Okay, thank you.
Thank you.
Just a question around the QSAC's kind of side of this. Given the custodial sentences that were imposed at court obviously would take into account more than just the facts of the offence, as in the scenario. How did you guys kind of deal with that there would have been mitigating and aggravating circumstances related to the specific offences?
We really sort of just did the best we can by matching what we could. There are, of course, circumstances within each case that we weren't able to match upon, and because the scenarios weren't super detailed, that we couldn't always match on everything. There were some things that, like in hindsight, looking at some of the scenarios, that perhaps we should have tweaked them a little bit to match the data analysis a little bit better. But, you know, in hindsight, it's always easy. But yes, there are definitely things within the data that we aren't able to match in. It's just the best we can do.
Thanks. Yeah, really interesting presentation. I just had one question. I don't know if you mentioned, I just missed it. So for like a digital penetration offence, is the maximum sentence the same whether it's a child or adult victim, or is there differences in what the court's able to do depending on age of the victim?
It's currently the same.
Okay.
Well, short answer.
Just in the context of the whole conference where we've been seeing increasing incarceration rates against decreasing crime rates, was there any consideration given to, rather than just the continual, let's up the penalty for this and then 10 years later we'll up the penalty for something else and then so on, was there any consideration that maybe the correction is to drop the penalty on some other offences?
Interesting thought. Not as far as I'm aware, but the recommendations that are made are developed by our council members, not by us as the data team. So I wasn't, privy to the conversations that were had. So I'm perhaps not the best person to answer that question.